welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host Ostika Das and I'll take you through the most significant courtroom developments from across the nation. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In this episode, we are going to talk about Umar Khalid's bail application, the Adani-Hindenburg controversy, the Bihar Caste survey, Nuh Violence, Manipur clashes and much more. So let's dive into the headlines. We begin with a development in the Adani-Hindenburg controversy. The Securities and Exchange Board of India has sought a 15-day extension from the Supreme Court to wrap up its inquiry into allegations against Adani Group of companies of widespread manipulations and malpractices to inflate its stock price. In its application, SEBI has insisted that substantial progress has already been made, detailing the current stage of progress for each case being investigated. This is the second time the market regulator is asking for an extension to complete its probe. In May, they requested for a 6-month extension but were granted 3 months, with the deadline expiring on the 14th of August. A bench headed by Chief Justice Chandrachud will take up this batch of petitions again on 29th of August. No bail for former JNU scholar and UAPA accused Umar Khalid yet. His bail plea in the Delhi riots larger conspiracy case saw an adjournment by the Supreme Court this week. This is the 4th time the bail hearing has been adjourned since the top court agreed to take the case on board in May. On the last occasion, the hearing was postponed due to Justice Prashant Kumar Mishra's recusal. Arrested in September 2020, Khalid awaits trial under the Unlawful Activities Prevention Act for his alleged role in the communal violence that broke out in the national capital in February of 2020. Khalid's incarceration has spanned over 2 years and 11 months. Last week, we told you that after stressing the need for an enduring, out-of-court solution to the problem of hate speech on earlier occasions, the court suggested a plan of its own, which is to direct the Director General of Police of each state to form a committee that would assess the hate speech complaints and issue appropriate directions to the concerned police officer, as well as periodically review the progress in all ongoing cases. Although the hearing was adjourned this week, the courtroom witnessed a noteworthy moment. Responding to concerns about provocative slogans against Hindus allegedly raised at a Kerala rally by youth wing members of the Indian Union Muslim League, Justice Sanjeev Khanna categorically stated that hate speech from either this side or that will be treated alike and dealt with as per the law. He also said that this was something the court had already expressed its opinion on and hardly bears repetition. Let's now turn our attention to the caste survey conducted by the Bihar government, which received the green light from the Patna High Court last month. The key highlight from the recent Supreme Court hearings is that there will be no stay or temporary stop to the publication of the survey findings. A bench headed by Justice Sanjeev Khanna has unequivocally stated that the court will not be issuing any such order without first hearing all parties involved and unless a prima facie case for stay is established. Senior advocate C.S. Vaidyanathan led the charge for the litigants challenging the caste survey. Appearing on behalf of NGO Youth for Equality, the senior counsel argued that the 2017 Puttaswamy ruling on the fundamental right to privacy necessitated a just, fair and reasonable law to infringe on privacy. Such a law must additionally stand the test of proportionality and have a legitimate aim. An executive order of the government could therefore not take the place of such a law, and even more so when it did not indicate at all the reasons for undertaking this exercise. Apart from this, Vaidyanathan also raised privacy concerns over the mandatory disclosure requirement under the survey. In response, the bench questioned if the right to privacy under Article 21 of the Constitution would be impacted, given the government's plan to release only aggregated and not individual data. Justice Sanjeev Khanna also asked if conducting a caste survey in a state like Bihar, wherein the judge said everyone knows their neighbor's caste, breached participants' privacy. In related news, CPIM leaders Brinda, Karat and KM Tiwari have formally approached the Supreme Court and asked to be made parties in this ongoing case against hate speech. A petition filed by journalist Shaheen Abdullah against the country's growing climate of hate and hate speech formed the core of the matter. Numerous applications have been filed from time to time, bringing the court's attention to incidents of hate speech or even its possibility at a scheduled event. The recent application filed by Karat and Tiwari seeks action against alleged calls for the social and economic boycott of Muslims by Vishwa Hindu Parishad, Bajrang Dal and other groups at rallies in various locations across Delhi. These rallies were prompted by the communal clashes that broke out earlier this month in Haryana. Next, we turn to Manipur, which has been witnessing ethnic clashes since May. We have two developments from the Supreme Court. First, the court has granted 2 weeks protection to Professor Kham Khan Sohan Hosing against coercive action. He has been implicated in 2 criminal cases, one for allegedly insulting the Meitei community during an interview with The Wire, and another for allegedly fabricating evidence for enrollment in the electoral roll. Earlier, the bench headed by Chief Justice D.Y. Chandrachud also granted similar protection to advocate Diksha Dwivedi against arrest. She was a member of a fact-finding team that visited Manipur. In another case, the court has agreed to consider a petition by 2 Kuki women seeking a direction to government hospitals to offer free medical care to those escaping violence in Manipur. Their petition also notes the resistance of the local police in registering first information reports and has accordingly sought guidelines for authorities to register 0 FIRs. During this week's hearing on the remission granted to Bilkis Bano's rapists, the Supreme Court raised questions about the selective application of the policy for premature release. After Additional Solicitor General S.V. Raju appearing for the Gujarat government argued for the convicts to be given a chance of reformation through early release, Justice B.V. Nagaratna posed crucial inquiries. Why is the policy of remission being selectively applied, and to what extent is the law being implemented among inmates? Why are our jails predominantly overcrowded, especially with under-trials? These are some of the questions the judge asked. The core of the state government's argument was that they had complied with the law while permitting the early release of the 11 convicts and taken into consideration all relevant factors mandated under the 1992 remission policy of the state of Gujarat. ASG Raju told the bench that even judicial opinion was sought and taken into account as required under subsection 2 of section 432 of the Code of Criminal Procedure. But this argument faced scrutiny from the bench over the question of jurisdiction of a district judge in Gujarat to render such an opinion when the trial was transferred out of state to Maharashtra. Once again, let me remind you to visit our website www.livelawlaw.in and read the detailed report on this week's hearing. The debate over premature release of the convicts will continue next week, so stay tuned. The Supreme Court has been hearing the batch of petitions challenging the abrogation of Article 370 of the Constitution, which stripped the erstwhile state of Jammu and Kashmir of its special status. The Constitution bench comprises Chief Justice of India D.Y. Chandrachud and Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gavai and Surya Kant. Senior advocate Rajiv Dhawan highlighted the diversity of the Indian Constitution to argue that Jammu and Kashmir was not the sole state granted autonomy, which he deemed a fundamental constitutional aspect. He argued that the democratization of power was necessary and that without the existence of A, autonomy given to states, and B, special provisions and concessions given to people when needed, India would collapse. Senior advocate Dushyant Dave argued that Article 370 was not temporary because of time, but because the article had fulfilled its objective, therefore making it unamendable. But Chief Justice Chandrachud was not convinced and countered this by saying that there was over 64 years of constitutional practice applying Article 370 beginning from 1958 to 2018, so the article had clearly not ceased to exist. Dave also countered the argument that insurgency justified the reorganization of states into union territories. He raised concerns about the precedent this was setting, not just on the erstwhile state of Jammu and Kashmir, but on the entire country, which would allow any majoritarian government to disintegrate any state into a union territory to assume control. Senior advocate Shekhar Nafade highlighted adverse outcomes of the abrogation, including J&K's disproportionate representation in the Lok Sabha, which he said was a potential violation of Article 14. Senior advocate Dinesh Dwivedi emphasized that reducing J&K to a union territory undermined its dual governance system. He also argued that unlike other states, J&K hadn't signed a merger or standstill agreement with India and therefore it maintained internal sovereignty which could not be breached by the Indian government. That was a recap of the 6th and 7th day of the hearing. The arguments will continue on Tuesday and you will find out the detailed reports on each day of the hearing on our website. The Shri Krishna Janmabhoomi Mukti Nirman Trust has appealed to the Supreme Court for a scientific survey of the premises of the Shahi Idgah Mosque in Mathura, which is believed to be built over the birthplace of Hindu god Krishna. This request follows the Allahabad High Court's dismissal of their writ petition, which sought direction to a local court to decide on a scientific survey first. The trust is dissatisfied with the High Court's approval of the local court, prioritizing the question of maintainability raised in the Mosque Committee's application to reject the plaint before considering the trust's application for an independent survey to ascertain the site's true nature. The Supreme Court has ordered a halt to the demolition drive conducted by railway authorities in a settlement near railway tracks in the backyard of the Krishna Janmabhoomi in Mathura. The order came after senior advocate Prashant Chandra Sen argued that continuing the drive could render the petition infructuous. After hearing his submissions, the court ordered a 10-day status quo and allowed the petitioner to submit an additional affidavit. Railway authorities have defended the demolition, citing plans to convert a rail stretch from narrow to broad gauge to facilitate the operation of trains like Vande Bharat. Residents, however, have cried foul and alleged unfair eviction from the predominantly Muslim settlement. The Supreme Court has extended the Delhi government's deadline to finalize the Delhi Motor Vehicle Aggregator and Delivery Service Provider Scheme 2023 for regulating two-wheeler aggregators until September 30th. The move comes after the court's stay on the Delhi High Court's order allowing bike taxi aggregators like Rapido and Uber to operate without proper licenses. The Delhi government had earlier pledged to establish the policy by July 31st of 2023. This week, the Supreme Court heard a plea by News Broadcasters and Digital Association challenging Bombay High Court's critical remarks on media self-regulation in the context of the Sushant Singh Rajput case. The court expressed concerns over the effectiveness of the self-regulatory mechanism set up by the NBDA, especially the News Broadcasting and Digital Standards Authority. While acknowledging the NBDA's stance against statutory censorship, Chief Justice D.Y. Chandrachud emphasized the need for a more robust self-regulatory system. Notably, the court also questioned the adequacy of the current fines imposed by NBSA, suggesting a proportional fines aligned with the profits earned from disputed news broadcasts. During the hearing, Chief Justice Chandrachud asked, and I quote, "Is a fine of Rs 1 lakh for a channel really effective? Your fine must be proportional to profits you make from that show. We don't want to impose a pre-censorship or post-censorship on media, but the self-regulatory mechanism has to be effective. You virtually preempt the criminal investigation in such cases." The Supreme Court has reserved its judgment on whether children born from void or voidable marriages have a right to ancestral property under Hindu law. This case involves the intersection of Section 16 Clause 3 of the Hindu Marriage Act and Section 6 of the Hindu Succession Act. While Section 16 Clause 1 and 2 of the Hindu Marriage Act grant legitimacy to children from such invalid marriages, Section 16 Clause 3 restricts their property rights to their parents' self-acquired property. This week, a 3-judge bench headed by Chief Justice Chandrachud reserved its verdict after hearing this case, which was a reference of another judgment delivered by the top court in 2011 on the scope of Section 16 Clause 3 of the Hindu Marriage Act. The Supreme Court has observed that partition under Hindu law can be achieved not only through a written instrument but also through a settlement or oral understanding. This observation was made by a bench headed by Justice Bella Trivedi in a case pertaining to a woman's suit seeking co-partnership rights under the amended Section 29A of the Hindu Succession Act and requesting partition. On Saturday, the Supreme Court held an urgent special sitting to hear a rape survivor's plea for pregnancy termination after the Gujarat High Court refused her relief. She is an Adivasi woman from a remote village in Gujarat who was allegedly raped under the false pretext of marriage. The petitioner's pregnancy is nearing 28 weeks. When she was 26 weeks pregnant, a medical board found her to be clinically fit for the termination procedure. On 11th August, the board placed its report before a single-judge bench of the High Court, but the High Court delayed the matter and posted it to August 23rd. The Apex Court Special Bench, headed by Justice B.V. Nagaratna, expressed its dismay at the delay and the valuable time lost between 11th and 23rd. Not only this, the bench also ordered a fresh medical examination and directed the report to be submitted by Sunday, that is today. The case will be heard again tomorrow. The Supreme Court has ruled that maternity benefits would extend beyond the contractual employment term, while hearing an appeal against Delhi High Court order that limited such benefits to 11 days due to the expiry of a contract. The bench headed by Justice Aniruddha Bose highlighted Section 12 Clause 2 Subclause A of the Maternity Benefits Act, which grants benefits even to employees dismissed during pregnancy. The court emphasized that the statute itself envisioned benefits extending beyond employment terms and overrode all other agreements. After making these observations, the court directed the concerned employers to provide benefits under sections 5 and 8 of the Act within 3 months. The Supreme Court has sought the assistance of the Attorney General for India with respect to a plea urging a fixed time limit for the centre to notify the Collegium's judicial appointments. The petitioner argued that the absence of a time limit for notifying appointment created uncertainty. Referring to the Supreme Court Advocates on Record Association case, the petitioner asserted that the centre lacked discretion on both whether and when to notify appointments. The petitioner cited Articles 14, 19 and 21 contending that delayed or denied appointments violated fundamental rights. The Supreme Court has on many occasions expressed grave concerns over delayed appointments, especially over the vacancies in the high courts of the country, and urged the central government to notify appointments immediately after the Collegium cleared their names. In 2021, a bench headed by former Chief Justice S.A. Bobde had in fact provided a timeline and advised the centre to follow it. The centre has introduced a draft standard operating procedure for the appearance of government officials in court during government-related litigation. Let's quickly go over the key suggestions. The SOP recommends officials' presence only in exceptional cases with prior notice and an option for virtual appearance. Courts are urged not to comment on officials' appearance or background. Where the lead ministry or department has responded, courts are advised against mandating the presence of officials or requiring additional affidavits from ministries or departments listed as pro forma. Quasi-judicial orders challenged in appeal should be reviewed for legality and not facts. Criminal contempt should be pursued only if willful, and judges should not handle contempt of their own orders. When executive matters are involved, courts should refer the matter to the government rather than summon officials. If the government seeks an extended time frame for complying with court orders, such requests should be granted by the court if deemed reasonable. That was the summary of this draft standard operating procedure, the goal of which, according to the central government, is to improve the relationship between the judiciary and the executive and enhance compliance with court directives. The Supreme Court has unveiled the Handbook on Combating Gender Stereotypes, a legal glossary addressing inappropriate gender terms and stereotypes in legal discourse. Chief Justice D.Y. Chandrachud led the initiative to release this comprehensive guide that aims to counter gender stereotypes in language and thinking. The handbook, crafted by a committee chaired by Calcutta High Court Judge Moushumi Bhattacharya, not only identifies and offers alternatives for what the Chief Justice has said is gender-unjust language, but also highlights flawed reasoning patterns based on such gender stereotypes. It further emphasizes landmark Supreme Court decisions that have rejected these biases and contributed to a more inclusive legal environment. The Rajasthan High Court has termed the chest measurement test for women applicants wishing to join the Forest Guard as arbitrary and demeaning. Justice Dinesh Mehta's bench emphasized that chest size did not reflect strength, and this criteria violated women's dignity and privacy. The court harshly criticized the criteria as scientifically unfounded, humiliating and unjustified, and suggested exploring alternatives for assessing lung capacity. Although the court did make these critical observations, it did not allow the writ plea filed by a group of unsuccessful candidates on the ground that the recruitment was already over and the petitioners had subjected themselves to such a test. The Jharkhand High Court has exempted Congress leader Rahul Gandhi from appearing in person before a Ranchi court in a defamation case relating to the "Why all thieves have Modi surname" remark. The court cited precedent and the fact that Gandhi is a sitting member of parliament, busy with parliamentary sessions, and allowed him to be represented by his counsel in court under certain conditions. Following the communal violence in Nuh and Gurugram in Haryana, demolition drives were conducted to remove what the government said were illegal constructions, shanties, shops and structures. These allegedly belonged to people involved in these clashes. But this was stopped after the Punjab and Haryana High Court intervened. The court temporarily halted the Nuh district's demolition drive, citing apprehensions over due process and the potential targeting of a specific community. The court questioned if law and order issues were being used as a pretext for demolishes without proper legal procedure, potentially amounting to ethnic cleansing. In response to these concerns, Haryana's Deputy Commissioner has now insisted that demolitions adhere to legal procedures and were not biased on the basis of caste or religion. The Madras High Court has held that registered medical practitioners need not demand the name of a minor seeking pregnancy termination from consensual relations while preparing a report in terms of Section 19 of the POCSO Act. This is because the minor and their guardian might not want to proceed with legal action. The bench also directed the Principal Chief Secretary to ensure adherence to this decision and compliance with the Supreme Court's ruling against name disclosure. The bench headed by Justice Anand Venkatesh was constituted to monitor the implementation of provisions of the POCSO Act and the Juvenile Justice Act on the judicial side. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications. And lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host, Ostika Das, and I will see you again next time.